Alright, what's going on, everybody? Lexi right here, and I am bringing you guys the third update of the EPO. And it is Tuesday right now. Court is on Thursday. Sorry, when I did the previous EPO, I said, the previous update, I said Tuesday. I meant Thursday. Sorry about that, guys. But it is Thursday, and I have the copy right here in my hand to pretty much like go over it with you guys, so you guys know pretty much exactly what's going on and what it is entitled and stuff like that. In case anybody was wondering about anything of it, well, this video can clear any of that up. So that's what this part is, and then the next part is after court, and I'll let you guys know what happened after court. So of course, I can't show a lot of this information because a lot of it is confidential, but pretty much it entails that Naomi Foster right there, the respondent, is the person we have it against. And I don't know if you guys can see that or not, but it says she's an alleged stalker. That's what she pretty much got known as around in Owensboro. And then where the caution is, I don't know if you guys can see that either, but they're both checked off saying weapon involved and armed and dangerous. So they already know that Naomi and her husband are pretty much dangerous people, and that he does own a weapon. And it pretty much was set forth that the respondent be restrained from committing further acts of abuse or threats of abuse, talking or sexual assault, and also that the respondent be restrained from any unauthorized contact with the petitioner, plaintiff, or other protected persons named in this order. And right now, this is only for 6 months until court date on Thursday. And the reason I'm giving like specific detail also is some way to clear anything up. If anybody's confused, wondering what's going on, this will clear any of that up. So it also, on this page, it pretty much entails that the respondent be restrained from any contact or communication with petitioner and all other protected persons named in this order, which is my mom. So they cannot even talk to my mom, do anything. Also, that the respondent remain at all times and places at least 500 feet away from petitioner and all other protected persons named above, which, being at the bus station, being on the buses, you're not 500 feet away from me on that. You're closer. It also says that petitioner having established specific demonstrable danger, respondent be restrained from going to or within the distances specified of the locations as described below, which is the St. Benedict's Women's Day Shelter. And that respondent be restrained from disposing of or damaging any property of the parties. It also says 500 feet right there. 500 feet, they can't be around. And there's no, there is no children involved. We don't have to worry about any of that. But OJ is on here under pet. In order to assist in eliminating future acts of domestic violence and abuse, dating violence and abuse, stalking, and sexual assault, no third-party contact. And this is right here, this is the protective order summons. This is what it looks like here in Kentucky. In case anybody was wondering what it looks like here in Kentucky, or in Owensboro at least, this is what it looks like. Where on the top it says, me versus Naomi. And it has her residence address, which we got wrong. We know the correct address now. It has all her information right there. It says still that the caution is weapon involved and believed to be armed and dangerous. And the date and time for us to go to court and the location where it's going to be. So she got this page as well. She was served this page as well. She was also served this page here where it was all talking about, why I needed the order. I'm not going to read all of it because it was, the big paragraph. I think I read it on part one. It was either part one or part two. I think I did on both. But pretty much it just shows, the same thing. My name, her address, and her information, and it just shows what happened and why I need the order, pretty much. And if you're wondering what that is, you can check out part 1 and part 2. And this page is continuance of the description of why I need the order. And this page here pretty much shows that petitioner or petitioner on behalf of a minor child, which we don't have, it's that part wasn't checked, that issue an emergency or temporary protective order based on the presence of an immediate and present danger of domestic violence and abuse, dating violence and abuse, stalking, or sexual assault to restrain respondent from committing any further acts of domestic violence and abuse, dating violence and abuse, stalking, or sexual assault. Also, restrain respondent from any unauthorized contact or communication with petitioner or other person specified by the court. If other persons are in need of protection, provide name, all their information. So I did. I put my mom down and her information. Why? Because of attempted assault and harassment. Stated right there. And also to restrain respondent from going to or within a specified distance of a specifically described residence, school, or place of employment or area where such a place is located. And this part's important. It says St. Benedict's Women's Day Shelter, bus station, bus stops, or any of the buses. And it says why, what danger exists, attempted assault, threats of violence including use of firearms, stalking. And it's right there. And why is that part important, you may ask? Because the cops keep overlooking this. Every time they get to the bus station, and we have to call the cops on them because they're violating this order right here, then we try and explain it to the cops like it says right here that they cannot be at the bus station or a bus stop like this. They cannot be, at a bus stop. And the cops keep overlooking it, saying, no, that's not true. It's only the day shelter, because of it only saying that on the previous pages. And this page here, why is everything blacked out? Well, pretty much most of it's blacked out because it entails too much confidential information. But pretty much the reason I'm sharing this one is because it has a check mark on none of the above relationships apply, but respondent is alleged to have committed stalking, which is checked off right there. Stalking. The court knows they freaking at least did that. And I have the proof of the assaults all on camera, which I'm going to show them on court. And this page here is a summons for her husband Dwayne having to go to court or the police station, and he had to surrender all firearms currently in his or her possession to the sheriff. So he had to surrender, and I asked somebody, does that mean he had a weapon then? They're like, well, it says to surrender weapons. So yes, he did. He had one on him. He had to surrender it to the police station. So the cops and the courts already know that he does have a weapon, so they know that most of what I say so far of what they've read, why I need the order, is true. They'll believe all of it once I have the proof. I give them all the evidence, they'll believe it all. And, this is the last page, and it says that it's grant other relief which would assist in stopping further violence or abuse, stalking or sexual assault, which is listed on here that she has charges of menacing, attempted assault with a weapon, mental abuse, emotional abuse, harassment, stalking, threats involving weapons or without weapons, terroristic threatening. Cause a summons to be issued to respondent, which means that she's going to get her order just like this, and she's going to get the date and time that I showed before. So she has an order that just like this. She got the same order on Friday night. So she was served, Dwayne was served, so they know that they got court. He had to surrender his weapons, so that was true that he did have weapons on him, that they are dangerous. They were armed and dangerous, so that now he don't have anything because he had to surrender them to the police station. So, yeah, and I will update you guys on what happens after court on Thursday, but I did this part because if anybody was confused, if anybody was wondering, if anybody had any questions, well, hopefully that could be cleared up, and a lot of that information is going to be, edited out just for confidentiality and privacy reasons and stuff like that. Not everything on the order is meant to be shown here on YouTube, only specific parts that I'm talking about, trying to clarify with you guys. So, yeah, so I will see you guys on Thursday. This video is going to be like 2 days long, Tuesday and Thursday, but somehow get Wednesday out of it. But yeah, it's going to be filmed again on Thursday, and I'll be explaining to you guys what happened after court. And I'm sure I'll put the camera up, letting you guys know that we are on our way to court and everything else. So I will let you guys know what happens. I'll see you guys after court. Peace out, everyone. See you guys after court. Alright guys, so today is Thursday, which means it's court day, and right now it's about 6 a.m. and court's not until 9:30. But we are ready to go. We are ready to go, guys. So a couple of my witnesses are no longer available. I'll just put it that way. I'm not going to put their information on why they are not available due to privacy reasons. But so I don't have any witnesses. So what I'm gonna do is when it's time for me to call a witness, I'm gonna call my mom up as a witness right here. I'm gonna be like, yes, I got my witness, Jennifer Sack, and I'm gonna be calling her up. So that's what I'm gonna do, and then I'm gonna cross-examine them, the two that the order's against. I'm gonna cross-examine, and then I'm gonna be questioning my witness, for more proof. I'm gonna be showing the proof today. And in case anybody's wondering, in case anybody's questioning, can I film inside court? Can I get a snippet of the court hearing? No, I cannot. I cannot film inside court. You cannot do that. It will turn into a federal charge, and I'll end up in federal prison for it. So I am not going to do that. I cannot film inside court. So apologies for that. So, but I will be explaining what happened after. Once court's over, I'll pick up the camera again, and I'll let you guys know what happened. So we got the questions ready. We got the opening statement, the cross-examination, the questions for my witness, the questions for their witness if they bring anybody, and then the closing statement. So, and including all the proof. So, and what I'm going to be also doing is getting a summons, like a summons of some sort, so that way I can give that to the day center and get the camera footage from March 16th and March 17th. So when I get that summons, they'll mail it to the day center, and Jesse won't have a choice but to hand over the footage to the court system, which then they can look at it and, see more proof, more evidence. So I have video evidence here on my phone, which is going to be shared in court today and stuff like that. So yes, oh my gosh, I don't know about my mom, but I am nervous. And it's like, just dealing with court systems in general just makes me nervous. I don't know why. But, yeah, so I'm just nervous in general just to be around the two the order's on anyway. Nervous as all get out to be around them anyway. Let alone just sitting there waiting for our case to be called and stuff like that. So I'm hoping that they don't even show up, because if they don't even show up, then that means that the order will be immediately granted, just like it happened in Ohio. It happened in Ohio like that when I found the last TPO, which is here on my channel with all those 3 updates and everything else about the last TPO I put on somebody in Ohio. That's what happened. They didn't show up, and the order got granted immediately. Just the judge was like, all right, yep, the order's granted, and they got served their copy the next day. So they didn't even show up. And then I remember getting text messages or something like that saying like, yeah, we didn't want to show up because we didn't want to make you look stupid or something like that, something to that effect. And basically what the truth was, is that they didn't have a vehicle. And the hill that we lived on was pretty steep, so they just didn't want to walk to court, which court in that town was walkable to. You could literally just, where the courthouse was, the courthouse we had to go to, and everything was on the main road, and you just could literally just walk to it. So that's just what it was. They just didn't want to walk to court. They couldn't find a ride. They couldn't. No, none of their friends wanted to, give them a ride to court. So that's the truth on what happened with them. They just lied and said, "Oh well, we just didn't want to go." Like, man, just be straight up, But anyway, so we're hoping that's just what happens again today. That it's against this time. We're hoping that they don't even show up, so it just immediately gets granted, and then they get served their copy again today. So either way, they're gonna get their copy again today. So either way, it's gonna be granted if they show up or not, because we have just all the proof. We just have it all the evidence. We just have it all. So, but I will pick this back up when we get done with court, and I will let you guys know what happened and stuff like that. I'll pick this back up after court. So I will see you guys after court. Wish me luck, guys. Peace out. Alright, guys, so this is after court. We did the court hearing and stuff like that. It was pretty much just like how I did it in Ohio. Basically, we went in there, and she was there too. We had to sit on separate tables. I was on this side, she was on this side. So it's and my mom was behind me and stuff like that. We had a domestic violence advocate and stuff like that to help us get into a domestic violence shelter if absolutely needed. And so basically what it started out with me giving the opening statement, and then I had to call my mom up as a witness. Unfortunately, the people that I originally had for a witness could not make it. So I had to, call my mom up as a witness, and it worked out. I was able to question her, and then after that, I was able to cross-examine. I had to ask Naomi questions, and then she was able to ask me questions, but she didn't want to. All she said was, "I don't want to talk to them." That's all she said, so she didn't have to ask me any questions or anything. So, but anyway, all she said was that she didn't want to talk to us, and so she didn't have to do any questions. She just had to answer any questions that I was doing through cross-examination. Once that was done, and the questions I asked my witness, once that was done, then I gave my closing statement, and then the judge, gave Naomi a chance to speak on if she agreed with everything that I was saying and stuff like that, what my witness was saying, everything else, which she, pretty much just lied straight through her teeth about everything. I mean, everything, you guys know, everything's, up here on my channel, pretty much everything that's been going on between us, it's all up on my channel, almost all of it. So, I mean, we had that, and I just want to put a quick disclaimer out there. You guys probably noticed me smoking a cigarette. Do not smoke cigarettes. I'm sure you guys already know that, and I'm not trying to order anybody around. I'm just looking out for people's safety that may be watching my videos. Please don't smoke cigarettes. Just because I do it don't mean you should. But anyway, aside from that, yeah, so basically she was lying through her teeth about everything and stuff like that. And then, but, the judge didn't really, because she admitted to almost a lot of everything that I was saying. She admitted to, telling me to, go harm myself. She admitted that she was around us. She admitted that she didn't try to avoid us. She admitted quite a lot of it. So the judge did find it and, in ruling to, grant the order, which is right here. This, the order is, granted for 3 years. And I'm going to go over a little bit with you guys. So it got granted as an interpersonal protective order. And it's for me against Naomi. And it has my name, my DOB, which they got wrong again. It says, none of the above relationships apply, but respondent is alleged to have committed stalking. It has her birthday and her social security number. Like, why do I need her social security number for? I don't need that. What am I going to do with that? I don't need it. But then it has her address, which is wrong too. It does state, don't worry, information that is shown on here will be blocked out. So it does show right here that weapon is involved, she is armed and dangerous. Well, it's really her husband that is. And it says down here, the court hereby finds that it has jurisdiction over the parties and subject matter, and respondent has been provided with reasonable notice and opportunity to be heard. And it says that the defendant was served on the 20th, March 20th. Additional findings of this order are set forth below. That respondent be restrained from committing further acts of abuse or threats of abuse, stalking, or sexual assault. That respondent be restrained from any unauthorized contact with petitioner, plaintiff, or other protected persons named in this order. My mom. Additional terms of this order are set forth below. The terms of this order shall be effective until March 26th of 2029. So it's granted for 3 years. You know, she can't come around me or my mom for 3 years. She can't even look at us. That's what the judge said. She can't even look at us. Wow. But yeah, it says additional findings is that for petitioner against respondent, and that it was established by a preponderance of the evidence that an act of domestic violence and abuse, it says that it was marked by stalking, and it says that plaintiff testified that defendant and her were at St. Benedict's. She and her and defendant ran up on her to fight her. Plaintiff states she was afraid for her safety. Defendant admits she pushed plaintiff after plaintiff started in on her, which is not true. Not true at all. Plaintiff stated and defendant admits she has told her on multiple occasions, telling her to herself and to I. Defendant states this was after plaintiff kept on and on about things. See Exhibit A, which is not true again. I mean, well, that one that I did put up, when the only time that I did catch her on camera was when I did happen to freak out. Was when I did happen to freaking have a meltdown, an autistic meltdown. But that doesn't, you know, so that one and only time was true. The only one and only time. But then it says that Kentucky license to carry is surrendered to court. She had to surrender her weapons. Her and her husband both had to surrender her weapons, which, you know, is proof that, okay, you did have weapons. No wonder I'm afraid of you. You mean you're gonna freaking just, you know, whip one out and start freaking banging on me or something? Like, I'm good, I'm all good, like, I don't want that, I don't want to smoke. You know? And then it also says that respondent be restrained from any contact or communication with petitioner and the following other protected persons, either direct or indirect, included but not limited to social media, i.e. Snapchat, Instagram, Facebook, Text Now, Cash App, PayPal, WhatsApp or Venmo, etc., and no third-party contact. That respondent shall remain at all times in places at least 500 feet away from petitioner and all other protected persons listed in this order, except as follows. Now, this is the part that angers me. Except as follows. The parties are authorized to remain in the following common areas closer than 500 feet under the limited circumstances and specific parameters indicated, which is here at the day center, which is, I'm not going to give their address out, but here at the day center, at the bus station, and any bus shelters for 10 feet. We can be around each other 10 feet. That petitioner having established specific demonstrable danger, the above named respondent to be restrained from going to or within the distances specified of the locations described below. The St. Benedict's Day Shelter. Again, it's listed. So, wait a minute. How is it that she's being restrained from the day center, but then is authorized to, except as follows, she's allowed to be here at the day center 10 feet away from me? Okay, I'm a little bit confused. Like, it says that she's not allowed here, but then yet you just have to be 10. I guess it's just you have to be 10 feet away from me, I guess. But that's just how I'm going to take it. That's just how I'm going to take it. Just stay 10 feet away from me. But it also says that respondent be restrained from disposing of or damaging any property of the parties, which, you know, we don't share any property. It was dated for today, and the judge signed it. And then this is the order that she got served with as well, which it says, me as petitioner, her as the respondent, stalking findings of fact. This matter having come before the court for an evidentiary hearing, and the court having considered the evidence and being sufficiently advised, the court hereby finds as follows. Stalking refers to conduct prohibited as stalking under KRS 508-140 or KRS 508.150 for an individual to be granted an EPO or DVO for stalking. He or she must at a minimum prove by a preponderance of the evidence that an individual intentionally engaged in two or more acts directed at the victim that served no legitimate purposes and would have caused a reasonable person to suffer sustainable mental distress, and these acts may occur again. Additionally, the individual must prove that there was an implicit or explicit threat by the perpetrator that put the victim in reasonable fear of sexual contact, physical injury, or death. And it says, plaintiff's mother, Jennifer Sack, I don't care to give her name out, testified defendant came running up on plaintiff and acted like she was going to hit her and was acting in a threatening manner. Plaintiff's mother stated defendant approached plaintiff on several other occasions in the same manner. Plaintiff's mother confirmed defendant has told her to die and to go herself. Plaintiff stated defendant appeared to be afraid. That doesn't make any sense. She wasn't afraid, I was. Defendant admits she pushed plaintiff out of the way and that she told her to herself. For these reasons, the court finds stalking has occurred. So, the order is set for 3 years. She cannot do anything for 3 years. Her or Dwayne can't do nothing. So, the court put it in effect. The order of protection, interpersonal protective order, is in effect. So, it was granted. Court went good. So, that's going to be the end of this EPO series. I hope that you guys did enjoy all the updates that I put up for you guys. And if it helped in any way for anyone being confused or wondering about anything, I hope it cleared it up for you guys and stuff like that. If you did enjoy this video, please let me know by smashing that like button and subscribing down below, because you know that this channel is just right for you. And this is going to close out today's video. I hope that you guys enjoyed, and I'll be back in the future with more videos. For now, and for right now, it's been Lexi Wright, and I am out. So, peace out, everyone. See you next time on a brand new video. Peace!